Hey guys, gonna run over this motion for sanctions by Ryan Reynolds. I expect it to be mostly, like very similar to Blake's that was filed yesterday. But we'll go over it, and if I see a lot of similarities, we're just gonna skim past that. I don't have a ton of time, so we're just gonna go right to it. Hang on. All right. Defendant Ryan Reynolds brings this motion for sanctions pursuant to FRCP Rule 11, requesting the court to impose monetary sanctions against Steve Sarowitz, Jamie Heath, Melissa Nathan, Jennifer Abel, and It Ends With Us Movie LLC, their attorneys Brian Friedman and Mitchell Schuster, and their attorneys' respective law firms. Counsel for the Wayfarer parties and 5 of their clients filed an amended complaint asserting claims for civil extortion, defamation, and tortious interference against Mr. Reynolds that do not and cannot exist. Mr. Reynolds provided the Rule 11 plaintiffs and their counsel an opportunity to save face, explaining these claims' glaring and fundamental defects and urging that they be withdrawn more than 21 days ago. Unfortunately, the Rule 11 plaintiffs and their counsel unequivocally refused to do so, offering no response on these defects except to argue that these issues are appropriately resolved by motion to dismiss and may later be supported by discovery. But these claims' fundamental failings are not about the parties' dispute as to the legal arguments relating to their claims, or the facts, or even that all of their claims are weak and meritless, which they are. Rather, it is about the fact that Mr. Sarowitz, Mr. Heath, Miss Nathan, Miss Abel, and It Ends With Us LLC, assisted by their attorneys, have knowingly brought claims for civil extortion, defamation, and tortious interference without any possible non-frivolous basis for doing so. One sec. I just walked back in the door to my house. All right. It is perhaps unsurprising that the Rule 11 plaintiffs have resorted to patently baseless claims against Mr. Reynolds. After all, at least one of the Rule 11 plaintiffs, Mr. Sarowitz, pledged to spend $100 million to ruin Mr. Reynolds and his family, allegedly. Never seen any proof of that. And Mr. Sarowitz's counsel declared his intent to sue Mr. Reynolds' wife, Blake Lively, into oblivion. Well, that did happen. Even a cursory review of the claims that the Rule 11 plaintiffs refused to abandon reveals their true and improper purpose to harass, annoy, and punish Mr. Reynolds while whipping up a public spectacle designed to distract from the emptiness of their claims against him. In sum, it is plain that Mr. Sarowitz, Miss Nathan, Mr. Heath, Miss Abel, and It Ends With Us LLC, and their counsel have violated Rule 11. Okay. Rule 11 imposes a duty on counsel to ensure any pleading or motion presented to the court is not frivolous, legally unreasonable, or factually without foundation, and is not being presented for any improper purposes, such as to harass, cause unnecessary delay, or needlessly increase the cost of litigation. Despite this well-known standard in their FAC, the Rule 11 plaintiffs asserted claims for civil extortion against Mr. Reynolds, even though they allege and admit that the only purported demand Mr. Reynolds made was with respect to Wayfarer, Heath, and Baldoni. By the Rule 11 plaintiff's own recitation of the facts, Mr. Reynolds never made any threat or demand as to Mr. Sarowitz, Miss Nathan, Miss Abel, or It Ends With Us LLC. Instead, the FAC does not even suggest Mr. Reynolds ever knew these parties existed. Oh, come on. Let alone communicated with or directed any extortive message towards them. You can't tell me he didn't know they existed. That's ridiculous. The Rule 11 plaintiff's defamation claims against Mr. Reynolds are likewise frivolous. They are only able to identify 2 statements that they can even claim Mr. Reynolds made, but they concede that each of those statements are exclusively about Justin Baldoni. To remedy this obvious shortcoming, the Rule 11 plaintiffs rest their entire defamation claim against Mr. Reynolds on unidentified statements that they imagine and theorize, but certainly do not allege based on any factual allegations that he might have made to third parties and the New York Times. But beyond a bald assertion that Mr. Reynolds had a direct role in such conduct, the Rule 11 plaintiffs do not actually make a specific factual allegation about what Mr. Reynolds did or said, nor do they even identify a theory, though that alone would be insufficient, of how Mr. Reynolds defamed any of the Rule 11 plaintiffs individually. Their refusal to withdraw their baseless claims, including with respect to defamation, confirms that the entirety of their claims rely upon a hope and prayer that discovery will somehow transform their frivolous claims into non-frivolous ones. But sue first, investigate later is the precise opposite of what Rule 11 requires. The same is true for the Rule 11 plaintiffs' tortious interference claims, in which the Rule 11 plaintiffs assert Mr. Reynolds interfered with their contracts or business relationships. The only contract or business relationship ostensibly interfered with was the one between Wayfarer and Baldoni, on the one hand, and WME on the other. The FAC contains no allegation, nor could it, that Mr. Reynolds took any action to harm a contract or business relationship enjoyed by the Rule 11 plaintiffs, as would be necessary to establish even the most basic elements of these claims. The Rule 11 plaintiffs and their counsel did not lodge frivolous claims against Mr. Reynolds by accident. They have had nearly 6 months to consider and investigate these claims, and have been on notice of the deficiency of their claims for much of that time. The Rule 11 plaintiff's lawyer, Mr. Friedman, has used the press to attack Mr. Reynolds at every turn, consistent with his apparent approach to lawyering, which he has described as ensuring that those he views as opponents of his clients will get what you get. Indeed, as demonstrated in Ms. Lively's amended complaint in this matter, Mr. Friedman has personally participated in the retaliation campaign against... Really, dude? In the retaliation campaign against her, including personally delivering numerous defamatory statements about Ms. Lively and her family. I don't see anything defamatory. Aggressive, sure. Like, there's nothing factually incorrect that he said to my knowledge. You'd have to prove that. The Rule 11 plaintiffs' refusal to withdraw or otherwise address these baseless claims raised during the Rule 11 safe harbor period makes plain that they and their counsel are acting with the improper purpose of harassing Mr. Reynolds, causing unnecessary delay, and increasing the cost of litigation. Well, then what do you call this? All right. If you guys haven't seen Not Actually Golden, she did a little breakdown of this yesterday, what this means, how the judge might handle it, that kind of stuff. So she's a good person to listen to if you want a more thorough legal explanation. All right. In light of these substantial violations, the court should impose sanctions. The first and most appropriate sanction is an award of attorney's fees incurred by Mr. Reynolds in connection with his defense of the frivolous claims, as well as in the preparation of the instant motion. This sanction should be imposed against plaintiffs' counsel and the Rule 11 plaintiffs. Further, in light of the pattern of improper and harassing behavior in which Mr. Friedman has already engaged in this matter, the court may also wish to consider whether additional sanctions are appropriate as the plaintiff's counsel. Okay. This is where we're going to see a lot of what we've already seen, so I'm not going to get into that too much. Okay. On May 13th, the final day of the safe harbor period, a partner from Liner Friedman, who has not appeared in this action, issued a letter to the undersigned counsel on behalf of the Rule 11 plaintiffs. In their letter response, the Rule 11 plaintiffs set forth no facts in support of their frivolous claims. Instead, they assert that group pleading is the alleged pleading defect in dispute, and that if the court deems this definitional issue to be a pleading defect, it is easily curable by amendment, without any insight into how they could cure such a deficiency besides withdrawing the claims. The letter response claimed that the Rule 11 plaintiffs have a good faith belief that further discovery will uncover additional evidence to support the claims of all Wayfarer plaintiffs, while failing to state what that evidence could possibly be, or why this case would uniquely allow for frivolous claims to be brought on a groundless prospect that they could later be legitimized. And therefore claimed that Mr. Reynolds' safe harbor letter and this motion are premature, which is, the same argument we saw yesterday. Oh, Leanne, yeah. No, Leanne's probably got an X thread out already, so definitely go check that out. Yeah, I don't know if we have any mods here with us because they're the only ones I can post links, but I'll do it. I'll do it after this. So, all right. Again, we're gonna skim through a lot of this stuff because it's gonna be like the same shit as yesterday. The civil extortion claims are legally unreasonable and factually baseless. Yep. The FAC alleges a single incident which does not involve any threats or demands directed towards Mr. Sarowitz, Miss Nathan, Miss Abel, and it ends with us, LLC. Okay. On August 12th, and they're quoting the FAC here, on August 12th, the talent agency executive communicated the demand from Lively and Reynolds that Wayfarer, Heath, and Baldoni make a public apology that day, and that if they failed to do so, the gloves would come off. Okay. I mean, we pretty much know all this stuff already, so. Simply put, the only threats or demands the FAC wrongly alleges Mr. Reynolds made were to Mr. Baldoni, Wayfarer, and Mr. Heath, and none of the others. To be clear, Mr. Reynolds' purported demand that Mr. Baldoni, Mr. Heath, and Wayfarer issue an apology is itself not extortion and is subject to dismissal pursuant to the Reynolds motion to dismiss. Okay. But it has nothing to do with Mr. Sarowitz, Miss Nathan, Miss Abel, or it ends with us, LLC, who sued him for extortion anyways. Confirming this, neither the Wayfarer party's exhaustive 168-page Exhibit A timeline nor their opposition to the motion to dismiss assert any factual basis that any of them possess, nor could ever reasonably possess, a civil extortion claim against Mr. Reynolds. No competent attorney could believe, after reasonable inquiry, that these allegations support the extortion claims brought by Mr. Sarowitz, Miss Nathan, Miss Abel, or it ends with us, LLC. Okay. Defamation claims. The Rule 11 plaintiffs have brought utterly frivolous defamation claims against Mr. Reynolds for making specific defamatory statements that they have now conceded do not concern and therefore do not defame them. When did that happen? Not saying it didn't, just don't know. Notwithstanding this concession, the Rule 11 plaintiffs have refused to withdraw or abandon their frivolous claims. Further, while they have posited that Mr. Reynolds defamed them through unspecified defamatory statements to third parties, that theory, even on its own terms, is plainly barred by settled law, that the Rule 11 plaintiffs do not challenge or seek to extend in this circuit for pleading defamation claims. The core of the Rule 11 plaintiffs' pleaded defamation claims against Mr. Reynolds turn entirely on Mr. Reynolds' alleged statements to WME that Baldoni is a sexual predator. But, as even a cursory review of these statements reveal, they have nothing to do with any of the Rule 11... Hold on, where'd that go? Plaintiffs, there we go. One sec. I swear there's a trash can over there. All right. The only other factual basis that the Rule 11 plaintiffs have claimed justifies their defamation claims as to Mr. Reynolds is legally improper under settled precedent in this circuit, and in any event is frivolous. They broadly assert, without any specific factual support, that Mr. Reynolds is directly liable for making defamatory statements to third parties, including the New York Times. Why am I wearing these? It's my favorite gay. Hi, Omar. Your brother won't be happy to hear that. Are you back from Mexico yet? All right. The Rule 11 plaintiffs have never articulated any basis capable of alleging defamation as required by settled law, namely what Mr. Reynolds is alleged to have said, when, and to whom. Worse, they do not even appear to have tried to do so. Despite their sweeping and fantastical pleadings, the Rule 11 plaintiffs do not identify a single third party to whom Mr. Reynolds made allegedly defamatory statements other than the New York Times. And as to that publication, the Rule 11 plaintiffs have refused to allege even one actual or even any hypothesized statement made by Mr. Reynolds. Any non-frivolous defamation claim against Mr. Reynolds would have included factual allegations as to what Mr. Reynolds purportedly told the New York Times, but no such allegations are to be found in the amended complaint. On your way to court. All right, well, I hope you win. Okay. The Rule 11 plaintiff's defamation claims as to Mr. Reynolds were plainly intended to harass, burden, and retaliate, all while delaying and increasing the cost of litigation. It's interference claims. The Rule 11 plaintiffs bring 3 interference claims against Mr. Reynolds based exclusively on purported relationships between other parties, Wayfarer and WME, and between Baldoni and WME. This was made abundantly clear in the opposition, which clarifies that while the FAC imprecisely pleads that the Wayfarer parties had a contract and business relationship with WME, the FAC clearly identifies Baldoni and Wayfarer as the Wayfarer parties who were represented by WME. The FAC's allegations that Mr. Reynolds interfered with Wayfarer's and Baldoni's WME relationship does not provide a reasonable basis for the Rule 11 plaintiffs to assert tortious interference claims of their own. There are no facts to support any contention that any of the Rule 11 plaintiffs were parties to a contractual or economic relationship with WME, nor any facts to suggest Mr. Reynolds interfered with any such relationships. It's not that they don't have a point. It's just that the same issues being raised here are also in the motion to dismiss, and I don't know if that matters because it's like I feel like they're the exact same arguments. The Rule 11 plaintiffs' baseless claims were brought for the improper purpose of harassing Mr. Reynolds. All right. We read this yesterday. I remember they wrote about the flood the zone tactics designed to confuse and mislead the public regarding the nature of this litigation. I don't know about that, but well, I mean, I guess I can see that actually. How they could be confusing and misleading to some people. I don't feel like I was confused by this at all. Like what they're writing here makes sense. Like I'm saying, I just don't know that this is the right avenue. And that's because I'm not a lawyer. So, all right. Yeah, dude, I just walked back in the house. I had to, because I'm leaving Tuesday? Monday. I leave Monday, and then I go to LA for a few days, and then I'm going to Sydney. So I had to cut some of that off. Thank you, though. All right. I mean, this is probably going to be pretty much exactly the same that they said about what Brian was doing. Yeah, filed 2 letters in an affidavit so inflammatory and improper that they were stricken from the record regarding the Taylor Swift allegations. On the contrary, he has repeatedly used the press to target Mr. Reynolds, including by asserting. Okay, so I guess they're putting in a bunch of block quotes again. I guess they're different ones than the ones about Blake, but we've seen all these in like various articles before. That Mr. Reynolds is arrogantly asking to be dismissed from the case despite his publicly documented involvement, extending far beyond just being a supportive spouse, and that after lighting a match, Mr. Reynolds now seeks to run from the flames. It won't work. Mr. Reynolds can appear on as many sketch shows as he wants and feebly try to make light of his current situation, but we will not stop until he is held accountable for his actions. I mean, are you not allowed to say stuff like that? I don't know. Is an attorney not allowed to say stuff like that to the press? Because I feel like the other side of this, is definitely saying some inflammatory things about Wayfarer in the press, including that Baldoni is some sort of horrible sexual predator, and Blake Lively has been targeted by abusive behavior. So Ryan's involvement is very well documented, and we will continue to discover more intentional misconduct. Was Disney actually complicit? I remember that. That was a recent one. Okay. What I make of that, the nice pool scene in Deadpool versus Wolverine, is that if your wife is sexually harassed, you don't make fun of Justin Baldoni. There's no question it relates to Justin. I mean, anyone can watch that. The hair bun, not the hair bun. If somebody is seriously sexually harassed, you don't make fun of it. It's a serious issue. As to Mr. Reynolds' appearance on Saturday Night Live, I'm unaware of anybody, frankly, whose wife has been sexually harassed and has made jokes about that type of situation. I can't think of anyone who's done anything like that, so it surprised me. I mean, those are opinions. They're not really opinions that most people already had, by the way. So, the immense power that Lively wielded in Hollywood built on pure fear of her husband. So that's a little, I might not have said that. and their powerful friends came to an end the moment Miss Lively planned a mass distribution of a disturbingly false and well-calculated hit piece in the New York Times. Power she wielded in Hollywood built on pure fear of her husband. Oh, I get it. It's other people's fear of her husband. I get it. Okay. Sorry. I thought he was saying her fear of her husband. I was like, whoa, maybe we don't go there in official press statements, but all right. My bad. While Mr. Friedman's current media blitz against Mr. Reynolds has been extensive, the Rule 11 plaintiffs' plan to harass and injure Mr. Reynolds began months before this litigation. As early as August 15th, shortly after the film's premiere, Mr. Sarowitz suggested to Miss Nathan and Miss Abel that they work to flip the narrative about Mr. Reynolds in the media to portray him as anti-feminist. Mr. Baldoni agreed this would be an easy flip, and Miss Nathan confirmed she was already working towards achieving this goal. I'm gonna have to go back and look at that because I don't recall him ever saying it would be an easy flip, but I'll take a look at it. Sometimes I just forget things. There's been so many of these stupid documents that my brain has to get rid of stuff to make room for more. All right. Mr. Sarowitz has further made comments to third parties about his willingness to go after Mr. Reynolds and his wife if they ever get him to that point. From the outset of this litigation, Mr. Reynolds has expressed concerns regarding statements made by Mr. Friedman and his firm relating to the present litigation, including a website that Mr. Friedman planned to launch, and we know about that already. Only includes court documents, by the way, so you can't really do anything about that. They're public court documents. All right. Mr. Friedman's misconduct continues as evidenced by his recent behavior. These public attacks, combined with the Rule 11 plaintiffs filing numerous claims against Mr. Reynolds without any basis in law or fact, is willfully improper and warrants sanctions under Rule 11b1. Okay. Oh, my team's just going off over there. The court should order plaintiffs' counsel and the Rule 11 plaintiffs liable for reasonable attorney's fees and costs to Mr. Reynolds. I'm just trying to skip over some of this really redundant stuff. Okay. The court should order Mr. Friedman, Mr. Schuster, Liner Friedman, and Meister Selig jointly and severally liable to Mr. Reynolds for all imposed sanctions. Okay. This is all the same as yesterday when it comes to Friedman. The imposition of meaningful monetary sanctions may be the only way to deter plaintiffs' counsel and the Rule 11 plaintiffs from continuing to unlawfully harass Mr. Reynolds with baseless accusations and statements to the press. As an illustration of the Rule 11 plaintiff's financial resources, Mr. Sarowitz has pledged his intention to spend $100 million to ruin the lives of Mr. Reynolds and his family. Again, that's like, you could have pulled that out of your ass. I have no idea where that came from. I've never seen it in writing. I've seen it in their writing a gazillion times, but I've never, seen it in the text or anything like that, the evidence that they presented. So that's just, I don't even know where they heard that. I doubt that Steve Sarowitz said that to him. And if he did, then I'm sure we'll hear about it, but I don't think so. Not to my knowledge, anyways. Wait, I just clocked that Friedman dropped that arson gem, considering Ryan admitted to burning down a part of his school. I didn't think about that. I didn't even think about that. That's kind of funny. No, I really did not register that at the time. That's awesome. All right. Given those intentions, which there is every reason to believe have evolved into a bottomless bank account funding the Rule 11 plaintiffs' instant litigation, the imposition of material monetary sanctions becomes critical. Okay. All right. Then we have, they show the safe harbor letters again, same as yesterday, that kind of deal, but let's see. They're probably all going to say the same thing. We'll read the one at the very end because that one's a little different. Dear Mr. Friedman and Mr. Schuster, on behalf of our client Ryan Reynolds, we write to address the frivolous claims asserted by plaintiff Steve Sarowitz against Mr. Reynolds, and there's one for each of the plaintiffs here that say pretty much the same thing. Okay. Let me go down to the bottom. Here we go. Okay, and this is where Wayfarer actually wrote back. The letters address alleged pleading defects that the lively defendants have already placed before the court in their respective motions to dismiss the First Amendment complaint. The gist of the letters is that the FAC's extortion, defamation, and intentional and negligent interference claims are stated on behalf of the Wayfarer parties as a group and do not state facts sufficient to state a claim on behalf of particular plaintiffs swept into the definition of Wayfarer parties. For instance, the lively defendants threatened sanctions against Jamie Heath on the asserted grounds that 1. Mr. Heath lacks standing to assert an intentional interference claim because the FAC does not allege that he is a party to the allegedly interfered with WME contract, and 2. The FAC fails to plead specific defamatory statements about Mr. Heath, but does so only about others included in the term Wayfarer parties. As another example, the lively defendants complain that Melissa Nathan is grouped under the umbrella of Wayfarer parties in the FAC's extortion claim, even though only Wayfarer, Heath, and Baldoni are proper plaintiffs. The lively defendants also object that the FAC's false light claim is properly stated only by Baldoni, Heath, Abel, and Sarowitz, and not Melissa Nathan. Okay. Simply put, group pleading is the defect at the heart of the lively defendants' Rule 11 letters. Such purported pleading defects, particularly those already before the court in a motion to dismiss, are not the proper subject of a Rule 11 motion. That's where I'm getting confused, because I'm reading this and I'm like, I swear to God, this is the exact same shit you said in your motion to dismiss. So, like, all right, we'll just have to see how that goes. I have absolutely no idea if this is like a normal thing to do or not, to be honest. I have no idea. Such motions are improper if they are substantially identical to the arguments made by defendants in support of their motion to dismiss for failure to state a claim. Okay, so yeah, that's exactly where I'm getting confused by this, but at the same time, it's like they're going to say that, right? And then the other side's going to say the opposite. So which one is true? I don't know. I know which one I want to be true. I don't know which one is actually true. So that's all I can really say about that. Why is it a problem that a billionaire is protecting himself and associates from another billionaire? That's a great fucking question. I don't know. It's a problem because the statement that they're attributing to him is sensational. So they need it to be a problem so they can keep saying it over and over again and make him look bad. I guess that's how I feel about it. I don't know, man. It's funny to see narcs accuse other parties for their actions. They really believe that everybody is like them and try to bend the truth. Fortunately for sane people, the truth can't be bent. Yeah. All right. The Supreme Court has recognized the flexibility provided by Rule 11b3, allowing pleadings based on evidence reasonably anticipated after further investigation or discovery. Discovery is in its infancy, and the extensive allegations in the FAC support the Wayfarer plaintiff's good faith belief that reasonable investigation and discovery will uncover additional evidence to support the claims of all Wayfarer plaintiffs. In sum, the lively defendants' 12 letters claiming that the Wayfarer parties have violated Rule 11 are in themselves frivolous and contrived solely to harass and increase the cost of litigation. So we're both just like, you're harassing me and trying to build up my cost. You're harassing me and trying to build up my cost. So this is not at all exhausting. Such hardball litigation tactics, including threats of Rule 11 sanctions, are improper. Any motion for Rule 11 sanctions will be addressed accordingly. Okay. And this was, what, a week ago? Yeah, a week ago. Okay, so. So yeah, that was largely the same as what was in Blake Lively's motion for sanctions, just like some different block quotes and shit like that about how they think that he's harassing Ryan Reynolds in the press, which is, okay. Even if that were true, I wouldn't be very sympathetic, you know? So, But when it comes to what attorneys are and are not allowed to say in the press, I have a lot to learn. Lot to learn. So I don't want to speak on something I don't really understand. You know what I mean? I know they're allowed to talk to the press. There was no, um, sorry, I'm trying to read my text from my mom. There's nothing preventing them from talking to the press at the moment, but um, I don't know how far they're allowed to go with that. So, all right, it's time for me to get back to work. Oh, hang on. Omar says sanctions are premature. This motion is a whiny 4-year-old demanding cookies before dinner, bro. All right, man. Well, maybe we can talk about that some more later because I have lots of questions about this stuff. So, all right, thanks everybody. I appreciate it. I got to get back to work. So, bye.